Welcome back to yet another episode of Tax Month. We hope that you are keeping safe and doing well. The topic of today's session is the much debated and deliberated Faceless Assessment Scheme. For the sake of convenience, we have, once again, bifurcated the session in two parts. In the first part, we are going to briefly touch upon the broad contours of the Faceless Assessment Scheme, discuss what it is all about, and answer some of the related issues which have ultimately landed up in courts across the country. In the second part, we shall continue with our deliberations with yet another set of complex yet virgin issues concerning faceless assessment. Friends, as we all know, that faceless assessments were, for the first time, introduced in 2019, September 2019 to be precise. As a first step, amendments were made by way of Finance Act 2018, empowering the central government to notify a new scheme to carry out assessments electronically so as to impart greater efficiency, transparency, and accountability in the manner of making assessments. The objective was to eliminate person to person interaction between the assessees as well as the tax officials. The aim of faceless assessments was to carry out a team based assessment exercise with dynamic jurisdiction. In furtherance of this objective, on 12th September 2019, the central government notified the e-assessment scheme, which was later renamed as the Faceless Assessment Scheme by setting up the NFAC, that is, the National Faceless Assessment Center. Subsequently, the entire scheme came to be codified by enactment of a new provision under the Income Tax Act, that is, Section 144B. The Faceless Assessment Scheme, which saw its first implementation in the assessments undertaken during the months of April to June of this year, threw up, as expected, a variety of challenges and several technical questions which were required to be deliberated and addressed. By way of the present Tax Mantra series, we aim to discuss and unlock these issues which have a crucial bearing and are relevant not only for taxpayers but also tax consultants. With that introduction, I would like to call upon Mr. Rohit Jain to delineate and answer the salient features of the Faceless Assessment Scheme.
I think before I come to the salient features, let me start by saying that faceless assessment is one of the very laudable initiatives which has been taken by the government and the legislature. Now there are few points which have to be kept in mind. First of all, as Aniket pointed out, initially the assessment scheme was brought into effect in the form of a faceless assessment scheme, which was later on codified in the form of Section 144 capital B. The faceless assessment scheme was in force till 31st March 2021, which effectively means that all assessments which are required to be made till 31st March 2021 were to be made under the faceless assessment scheme. All assessments which were to be made after 31st March 2021 were to be passed under Section 144 capital B of the Act. Now, this is a very important aspect of the faceless assessment scheme. Now, because of the COVID and there were extensions which were given by the authorities from time to time, what had really happened is that assessment which were required to be completed by 31st March 2021 actually spilled over and moved on to April, May, June, etc. Effectively, it means that assessment which were earlier undertaken under the faceless assessment scheme ultimately were culminated in the form of either the draft assessment order or the final assessment order under Section 144 capital B of the Act. So therefore, to some extent, there is an overlap of the earlier faceless assessment scheme and also the newly codified Section 144 capital B. That is one aspect. Now, coming to the salient features of the faceless assessment scheme, I would break down this salient features into 4 or 5 steps. The first step is basically collection of information by an NFAC, wherein the questionnaires are issued, the details are required to be uploaded into the system, and which are required to be considered by the assessment unit. That is the first aspect. The second and most important aspect is, before passing of the final assessment order, the scheme provides that the NFAC or the assessment unit will first prepare a draft assessment order. This draft assessment order is required to be prepared by the assessment unit of the NFAC, whether or not any variation is proposed to the returned income. This is very important. Once the draft order is prepared, it goes to the NFAC, which is the main center. NFAC, as per the risk assessment strategy, which has been probably devised, ultimately screens through the assessment order. In case the assessment order passes through the risk management strategy of the NFAC, then the NFAC is required to see whether the draft assessment order which has come to it is contains any variation or not. If it does not contain any variations and it also passes the risk management strategy of the NFAC, then the NFAC can proceed to pass a final assessment order, and the draft order itself becomes the final assessment order. However, in case it does not go through the risk management strategy of the NFAC, then the NFAC has an option to refer to. In fact, I would say that if it does not pass muster to the risk management strategy, it will go to another assessment unit, wherein the new assessment unit will again go through and pass a revised draft assessment order. That is one aspect. If the draft assessment order is not sent to the review unit, then in that situation, the draft assessment order is sent to the assessee, which is a mandatory requirement. It is to be sent to the assessee along with the show cause notice, pointing out that this is the draft assessment order. These are the variations which are proposed, and the assessee is given a liberty to file its objections to the draft assessment order. Now, when assessee or the taxpayer receives the draft assessment order, it has a right to file its objection, which can be both legal objections as well as the factual objections. So that, according to me, is the fourth stage where we file our legal objection. Now, what is important over here is that there is a provision for grant of personal hearing as part of the procedure codified under section 144 capital B of the Act. But at times, the draft assessment order or the scheme itself provides that you have to opt for the personal hearing, and option has to be exercised. Of course, it can be given in the part of the submission which you file, but also can opt it for by on the portal itself. There is a column where you opt for the personal hearing. So once I places on record my legal objections, my factual objections, and opts for the hearing, then the next and the final step is where the assessing officer will go through your legal objections, factual objections, and he will have to give you a hearing. Now, about the hearing, according to me, there is a substantial debate, and I think this will be deliberated in later part of the deliberation which are going to happen. The provision for hearing is provided only through a virtual mode. So there is no physical hearing which is provided for under the scheme itself. So this is broadly the salient features of the scheme. One more aspect which has to be kept in mind, that once all this process is over, once I file my objections, once assessing officer considers my objections, he grants me a hearing. He is required to again pass a revised draft assessment order or another draft assessment order, which again goes through the same process of it going to the NFAC, NFAC again verifying it with reference to risk management strategy. And if there are variations which are proposed, but at this stage, the variations are not confronted to the assessee again. Variations are required to be confronted to the assessee again. Only a new variation is made, which was not made in the original draft assessment order. So these are the important aspects which have to be kept in mind as and when we receive the assessment order.
Thank you, sir, for providing your valuable inputs on the features and various aspects related to the faceless assessment scheme. I would now call upon Mr. Ajay Vora, Senior Counsel, to discuss that considering the novel and unprecedented approach and nature of faceless mechanism, how far, in his opinion, has the Income Tax Department succeeded in fulfilling the promise of accountability and fairness in assessments, while at the same time complying both in letter and spirit with the procedure outlined under Section 144B of the Income Tax Act?
This is a laudable initiative started by the government to try and eliminate the interface between the taxpayer and the tax administration. There are many checks and balances built into the system, as Rohit alluded in great detail. The draft assessment order is subjected to scrutiny within the department itself before the assessee is confronted. The response of the assessee is again subjected to that same scrutiny and review before an assessment order is passed. This is certainly something that is welcome. I would think that the troubles that are happening are initial or teething troubles, in as much as Rohit mentioned, we move from the National Faceless Assessment Scheme to this codified and mandatory National Faceless Assessment Center having to pass an order in terms of Section 144B. Now, that migration happened in no time. The earlier Faceless Assessment Scheme governed assessments up to 31st March 21, and thereafter, this new one Section 144B was introduced from 1/4/2021. But given the pandemic, the time limit for assessment has been extended from time to time. As a consequence, the assessing officer till the last date was not sure whether the time will get extended or will not get extended. And we've seen in actual practice that there have been many shortcuts taken by the assessing officer in order to keep to the limitation, which he was not sure at the stage when he passed the order that the limitation will get extended. And that's the reason why we see a lot of writs that have flogged the courts, largely with regard to the question that due opportunity or adequate time was not given for the assessor to furnish response, and the assessment was completed in a tearing hurry. But I think and I hope that going forward as things settle down, the department would be implementing this in a pragmatic manner, making available due opportunity that needs to be given to the taxpayer to present the point of view. Because prior to the issue of the show cause notice or the draft order, the assessing officer is not privy to what is going on within the department after he is furnished his response in writing to the question as issued. So hopefully, things should settle down. We should see good quality orders coming from the department, and from the limited orders that we have seen that have come out at the moment, I see a lot of uniformity in a pan-India approach that has been taken by the department. For example, if there is a question of disallowance under 14A, I have seen in multiple cases that it is one stereotype kind of view that is repeated in these orders based on the facts of the case. So you are really seeking to marry the facts of a particular case with the view that the department has already formed in that National Faceless Assessment Center. And that's implemented across assessment orders for different assessees. So to that extent, I think they are bringing about a uniformity in approach. And I would think, hopefully in course of time, this will be treated as a welcome initiative, and it will definitely eliminate the harassment to the taxpayer by eliminating the interface between the taxpayer and the tax administration.
Thank you, sir, for your valuable and insightful response. Considering the wide variety of violations and transgressions which have, at least in the initial phase of the implementation of the faceless assessment scheme, been suffered by assessees all throughout India, what do you think, Rohit sir, would be an appropriate remedy for the assessee to avail in case of such procedural or technical violations by the tax department?
I think there are two important aspects to it. First of all, what is the transgression which has happened, that is to be seen. And secondly, then on that basis, one has to obviously decide the remedy which one can avail. Now, as sir also pointed out that due to COVID issues, due to transition from the earlier scheme to the new section 144B, there have been few instances where the assessments have been completed in a tearing hurry. As it be pointed out, some of those instances are where the one procedure of section 144B has not been followed. So, for example, a show cause notice has not been issued and directly the NFAC passed the assessment order, final order, rather than passing a draft assessment order. The second instances which we have noticed is where a right to of hearing has not been granted to the assessee. So there have been similar kind of instances which have happened. Now these are jurisdictional issues. These are issues which goes to the root of the matter because these leads to violation of principles of natural justice. Now in this kind of a situation where these fundamental jurisdictional issues are being raised, there are two options which are available to the assessee or the taxpayer. One option is to simply file an appeal, which is a regular appeal. Of course, now it will be decided by the NFAC, which is again a something similar, a CIT appeal similar to NFAC, as which are who are doing the assessment. The second option, which is also available to the taxpayer, is to file a writ petition against an order where there have been violation of principles of natural justice, or there is a or violation of the mandatory procedure codified in section 144 capital B of the Act. What is also important to bear in mind that as we all know that normally an appeal is to be filed within 30 days of the receipt of the assessment order. However, due to COVID situation which is prevailing, and by virtue of the Supreme Court order, wherein taking suo motu cognizance, limitations have been extended. Presently, the limitation of filing an appeal is up to 15 July, when that matter is listed for hearing before the Supreme Court, and the Supreme Court may or may not further extend the limitation of filing of the appeals. So therefore, there is no issue of the limitation running out of filing an appeal before the CIT appeal. So it's a choice which is available to the taxpayer. If they want to file a writ petition, they can refile a writ petition challenging those fundamental jurisdictional issues before the High Court. And one important aspect is this is part cause of action against the NFAC orders arises in Delhi. So therefore, it is also open to the assessee to file writ petition in the Delhi High Court or in the High Court where the normal jurisdiction of that assessee is there.
Thank you, sir. So building upon it, what do you think, Mr. Vora, as regards the appropriateness of the remedies available to the assessee against the faceless assessment exercise?
Aniket, as we all know that the availing of a writ remedy under Articles 226 of the Constitution is actually a discretionary remedy. It is a constitutional remedy that the courts entertain a writ petition in the absence of an equally efficacious alternate remedy. Now, the courts have, by convention, imposed safeguards or imposed standards when a writ would be entertained. And as Rohit has pointed out, if there are violations of principles of natural justice, if the order that is impugned in the writ petition lacks jurisdiction, then the writ jurisdiction can be availed and the court would normally entertain the writ petition, notwithstanding that there is an alternate remedy available. Rohit touched upon the fact that you could file an appeal to the CIT appeal. I would think that in the given circumstances, if the order has been passed in violation of principles of natural justice or without following the mandatory procedure under section 144B, which in terms amounts to the order lacking jurisdiction, then in that situation, filing an appeal would not be an equally efficacious remedy for the reason that you will have to go through the rigmarole of going through the appeals at various levels. You will be called upon to pay 20% of the demand while the appeal is pending before the appellate authority. There will be proceedings initiated and penalty that may be sought to be levied as a consequence of the assessment that is made. So I would think that if one can establish prima facie violation of principles of natural justice or lack of jurisdiction in the National Faceless Assessment Center to pass the order, in as much as it has not strictly adhered to the procedure mandatorily prescribed in section 144B, that would be an appropriate case to challenge the assessment before the High Court in a writ petition. So that's a choice that the taxpayer will make, and I would think that writ today has proved to be an efficacious remedy against such orders which are passed in violation of principles of natural justice and or in violation of the mandatory procedure embedded in section 144B.
The foregoing discussion and the inputs of Mr. Vora and Mr. Jain clearly demonstrate that undoubtedly the faceless assessment scheme represents a laudable initiative by the government in imparting efficiency and rooting out corruption. And when implemented perfectly, it would definitely go a long way in boosting taxpayer morale and inculcating investor confidence in India as a taxpayer-friendly jurisdiction. However, given the nuanced and novel nature of faceless mechanism, which requires deployment of technological tools, coupled with deviation from traditional assessment procedure, it is necessary that such a scheme be accompanied by adequate training, and public awareness, as well as efficient and tested operating systems. With that, we come to the end of part 1 of this 2-part series. We hope you have enjoyed the current session and found it engaging and insightful. Stay tuned for part 2 of the present series on faceless assessments. Have a good day. Thank you.